What is this thing about celebrities and handwritten wills? I mean, my goodness. Hi, I'm Guy DiMartino. I'm a Northwest Indiana estate planning and probate lawyer, and today I'd like to talk to you about another celebrity with a handwritten will, and this is Tanya Roberts. You may know her, you may not. She played in Charlie's Angels many years ago, but she was mostly known because she was the Bond girl with Roger Moore in the 1990s. So this is the story. You know, we lost Roger Moore in 2017, and we lost Tanya Roberts here January 2021, and it recently happened that somebody took a handwritten will that she allegedly wrote and brought it into court and is trying to probate the will, and apparently the handwritten document gives everything to her common law husband. Indiana, we don't have common law husbands. You know, California, things are always done differently than in most states. But the question is, in Indiana, would this will suffice? Well, let's explain what is required for a will in the state of Indiana. So, here I am, Guy DiMartino, I want to make a will. I take my legal pad, I write the will. Last will and testament of Guy DiMartino. I, Guy DiMartino, being over 18 years old, of sound mind, body, blah, blah, blah. I want to give everything to my common law husband, my common law wife, blah, 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 blah. Okay. Is that a valid will? Well, we would have to determine if all the formalities required in Indiana to have a valid will are met. So, is it in writing? Yes, it's handwritten, but it's in writing. Did I have my mind? Well, it appears that I do have my mind, so I had the capacity to make the will. The next question is, did anybody force me to do it? Did somebody coerce me into making the will? Nobody coerced me, so that's a check mark towards a valid will. Next question, did anybody witness the will? In the state of Indiana, we need 2 witnesses to the will. Tanya Roberts doesn't say anything about witnesses to that will, and I don't know what the law is in the state of California, but in Indiana, we need 2 witnesses to Guy's will. You look on the bottom, there's 2 witnesses, 2 signatures, their name is written, their address is there. Hey, works. The other thing that is required in Indiana, number one, either you have to go to court and prove that the will was the will by calling the witnesses, or you can self-prove the will by the witnesses giving an affidavit or a statement at the end of the will. That yes, the person was of sound mind and body. Yes, the person knew what they were doing. There's a whole bunch of statements that they give. And if that is there, then once that goes to the court should accept that will into probate and say, yes, it's a valid will. We are going to follow it. So just to recap, is it in writing? Handwritten's fine. Did I have my right mind? Did I have the testamentary capacity to enter the will? Did anybody coerce me? Was I under duress? Did somebody have a gun to my head? Are there witnesses? Was it signed by me? Was it signed by the witnesses? All that stuff, goodwill, handwritten or typewritten. Any questions regarding a Northwest Indiana probate matter, you can always reach out to me. I am Guy DiMartino. Have a great day.